to everybody. And today topic is Mahr. We will say in English Dower. And this is the family law first year second semester topic. When you see in Muslim law, what are the things should be there? Let we go to the another screen so that we will see Dower. Dower means Mahr. Under Muslim law, we deal it like this: introduction, definition, nature of Mahr, importance of Mahr, legal consequences of Mahr, there is the rights of wife in case of a non-payment of the Mahr, who can change the Mahr, kinds of Mahr, difference between Sunni and Shia. These are the things we are going to deal in today online class. Now let us see the introduction. In pre-Islamic Arabia, when the institution of marriage as we know it today was not developed, many forms of sexual relationship existed. Some were hardly better than prostitution. Men, after despoiling their wives, often turned them out helpless and without any means. Under this background, Islam tried to provide a just treatment for wives. In a Muslim law, a husband can divorce his wife at his whim and to ensure that the woman is not left helpless and without any means. The concept of Mahr was brought in. It forces the husband to pay a certain amount to the wife, either at the time of the marriage or at the time of dissolution of marriage. This amount acts as a security to the wife in case she is turned out by the husband or in her old age. Rather, we can say it is a token of respect. The dower, Mahr is given. In this online class, I use the word Mahr, that is in English equivalent is dower. Let me see the definition. Definition is, in Islam, the Mahr, M-A-H-R, within bracket dower, is one of the rights of the wife, which is hers to take in total and is lawful for her, in contrast to the widespread practice in some countries, where the wife is given no dower. Evidence that the wife must be given her dower is found in many places. For example, the ayah interpretation of the meaning, and give to them women whom you marry their mahr, obligatory bridal money given by the husband to his wife at the time of marriage, that is mahr, with a good heart, that is given in the Surah Nisa. Let me see the dictionary meaning. In the dictionary meaning, in Islam, a mandatory gift from the bridegroom to the bride upon marriage in Islamic cultures. As per Tayyib, Mahr is a sum that becomes payable by the husband to the wife on marriage, either by agreement between the parties or by operation of law. It may be either be prompt, we will say in Muslim terminology, that is the Arabic terminology, muajjal, or deferred, and we'll say muwajjal, M-U space W-A-J-J-A-L, muwajjal. According to Amir Ali, Mahr is a consideration which belongs to absolutely to the wife. In one of the case law, that is in Sabr Nisa versus Sabdu Sheikh, in that case law, it is held that Muslim marriage is like a contract where wife is property and mahr is the price of our consideration. However, it is also true that non-payment of mahr does not void the marriage. So mahr is not purely a consideration. Let me see the nature of mahr. Mahr is an essential requirement of a Muslim marriage. Thus, it is obligatory for the husband to pay mahr to wife upon marriage. A wife has an unrestricted right to demand mahr from husband. In Abdul Qadir versus Salima, Justice Mahmood observed that mahr may be regarded as a consideration for conjugal intercourse by way of analogy to the contract for sale. It provides that the woman with the right to resist the husband until mahr is paid. This right is akin to the right of lien of a vendor upon sold goods while they remain in his possession and so long as the price for the goods has not been paid. In Nasra Begum versus Rizwan Ali, it was held that the right to dower precedes cohabitation. Thus, a wife can refuse consummation of marriage until meher is paid. The right of wife to her dower puts her in a similar position as that of other creditors. Just like other creditors, she must be paid out of the property of the husband. Thus, it can be said that meher is a kind of debt upon the husband incurred in marriage. However, at the same time, payment of meher is not a charge upon the estate of the husband unless an agreement is made to that effect. The interest that a wife has over the property of her husband in lieu of dower debt is limited to existing lawful position towards herself enjoyment only. It does not give her the right to alienate the property. After the death of the husband, she can sue the heirs for the dower, but the heirs are not personally liable for it. They are liable only to the extent of their share in the inherited property. A dower can also be secured by an agreement just like any other debt. In Syed Shabir Hussain versus Farzand Hussain, a father stood surety for the payment of dower by his minor son. After his death, his state was held liable for the payment of his son's dower. In any case, if the person and his husband died, even after that also, the legal heirs are liable to pay the mahar from the estate of the deceased. Now let us see the importance of mahar. Marriage in Muslim law provides an absolute power to the husband to divorce his wife. I repeat, marriage in Muslim law provides an absolute power to the husband to divorce his wife. It also allows the husband to have multiple wives. This often results in a desperate situation for women because they are left with no means to support themselves. Mahr mitigates this issue to a certain extent, though not full. Therefore, Mahr is very important for balancing the right of the husband and wife. Mahr is an absolute requirement of a Muslim marriage, and so, even if Mahr is not specified at the time of marriage, the law will presume it by virtue of the contract of marriage itself. Even if a woman stipulates to forego the Mahr, her declaration will be invalid. In Abdul Qadir versus Salima, again, Justice Mahmood has observed that the marriage contract is easily dissoluble and the freedom of divorce and of the polygamy to a husband place the power in the hands of the husband, which the Muslim law intends to restrain by the mechanism of mahr. Thus, the right of wife to her mahr is a fundamental feature of the marriage contract. Thus, mahr serves the following purposes. Number one, to impose an obligation of husband as a mark of respect to wife. Number two, to place a check on the power of the husband to divorce and polygamy. 3. To provide for a subsistence of wife in the event she is divorced by the husband. Now let us see the legal consequences of meher. That is, rights of a wife in case of non-payment of meher. And let us see in the point wise the legal consequences of meher. Number one, dowry is like a debt, and the husband is liable to pay it to the wife before the consummation of marriage. Until it is paid, the wife has a right to resist cohabitation with the husband. Number two, if the wife is in the possession of the husband's property, she has a right to retain it until dowry is paid. She does not get a title to the property and does not get a right to alienate it, but only the right to possess it, the property of the husband. Third, wife can sue heirs of the husband for payment of dower. Fourth, if the dower is deferred, the wife is entitled to it upon dissolution of marriage, either due to divorce or due to death. Number 5. Dowry is vested right and not a contingent right. Thus, even after the death of the wife, her heirs can demand it. And the last one, 6. If dower has not been agreed upon at the time of marriage, the courts can decide the amount of dower by taking financial status of the husband, age of wife, cost of living, property of wife into consideration. Here, in the online classes, sometimes I use the Mahr, sometimes I use the dower. But Mahr is equal in terminology in English is dower, and it is Islamic terminology is Mahr, Mahr, and English equivalent is Dower, Dower. Now we'll see right to refuse consummation, that is conjugal rights. That right is given, as I said earlier. And this, before consummation of the marriage, the wife is entitled to deny the cohabitation to the husband till he gives her prompt dower on demand. It is to be noted that under Muslim law, a husband has a right to cohabit with his wife and she cannot refuse the same without any reasonable excuse. After the consummation, only the husband and the husband side people give party or the dinner, which is said to be the walima. But non-payment of prompt dower before consummation is a lawful justification for the wife to refuse cohabitation. A Muslim wife can refuse to live with her husband and refuse him the sexual intercourse so long as the prompt dower is not paid to her. In the case of Nasra Begum versus Rizwan Ali, the Allahabad High Court held that the right to dower comes into existence before cohabitation and the prompt dower may be demanded even before the cohabitation. Where the wife is a minor or insane, her guardian can refuse to allow the husband to take his wife with him till the prompt dower has been paid. If the minor wife is already in the custody of her husband, such guardian can take her back on the ground of non-payment of prompt dower. But where the consummation has taken place even once, the wife's right to refuse consummation is lost. If the marriage has already been consummated, the husband's suit for restitution of conjugal rights will not fail on the ground of non-payment of prompt dower. However, the court has a discretion, even in such a case, to pass a decree for restitution of conjugal rights. I repeat, even such a case, to pass a decree for the restitution of conjugal rights subject to the condition of payment of prompt dower. In case of Anis Begum versus Muhammad Istafa Wali Khan, the facts were that in the marriage of Anis Begum and Muhammad Istafa, the prompt dower was rupees 15,000. The husband and wife lived together for some time and a daughter was born to them. Later on, Anis Begum left the house for her husband and refused to come back till her prompt dower was satisfied. Muhammad Mustafa, the husband, filed a suit for the restitution of conjugal rights. It was held by the Suleiman CJ at the time that there was no absolute right in a husband to claim conjugal rights unconditionally. The court have discretion to make the decree of restitution of conjugal rights conditional on payment of wife's unpaid prompt dower, even where the marriage already been consummated. Accordingly, the decree for the restitution of conjugal right was passed in favor of the husband, subject to his payment of rupees 15,000. That is the outcome of the case law. Now let me see the right of wife over the husband property. That is the second point. Dowers rank as a debt and the wife is entitled, along with other creditors, to have it satisfied on the death of the husband out of his estate. Her debt, however, is no greater than any other unsecured creditor except that if she is lawfully in possession of the husband property. She is entitled to that possession until she is able to satisfy her debt by the rents or issues accruing out of the property. She is also entitled to the possession against the heirs of the husband until her dower is satisfied. In any case, dower one should have to be paid. Enforcement of dower as a debt. And this point will be elaborated like this. Where the marriage has been consummated, the wife cannot enforce her claim by refusing conjugal right to the husband. In such a situation, the wife can recover her unpaid dower by maintaining an action in a court of law. She may realize it from the husband in the same manner as a creditor recovers his loan. If the husband dies, the widow is entitled to recover the amount by filing a suit against the legal heirs of the deceased husband. But the legal heirs of the husband are not personally liable to pay the dower. The dower is a debt against the estate of the deceased husband, which is inherited by the heirs. And the third point, which you said in nutshell in the above point, but we will elaborate in this here and there. The widow's right of retention. This right arises only after the death of the husband or after divorce. During the course of marriage, a wife does not have any right to retain the property. She should have obtained the possession lawfully. Right to retention is not analogous to mortgage. Thus, she does not get the title to the property in case dower is not paid. Further, if the property is mortgaged, the wife cannot retain the possession against the mortgagee. Wife cannot alienate the property. She has to satisfy the dower only through the rents or other issues occurring from the property. In the leading case of Maina Bibi versus Saudari Vakil Ahmed, one Moinuddin died leaving his widow Maina Bibi and some property. The respondents instituted a suit against the widow for immediate possession of the property. However, the widow claimed that she had the right to possession until her dower was paid. It was held that the respondents could have the possession of their share of the property after paying the dower to the widow. The respondent did not pay and the widow continued possession. Later, the widow sold the property. The deed showed that the widow tried to convey an absolute title to the property. The respondents again filed the suit claiming that the widow did not have the right to transfer the property because she only had a right to retain and did not have any right to title for herself. It was held by the Privy Council that a widow has the right to retain the possession of the property acquired peacefully and lawfully until she is paid her dower. Further, she has no right to alienate the property by sale, mortgage, gift, or otherwise. That is the outcome in that case law. And let me see who can change Mahr. A husband can increase the amount of debt at any time, though he can't decrease it. And here, Mahr is as a debt. A wife can remit the dower wholly or partially. The remission of Mahr by wife is called Hiba-e-Mahr. However, she would have attained puberty to do so. She does not have to be a major to relinquish Mahr. Only attaining the puberty is sufficient. The remission made by the wife should be with the free consent. Thus, in Shah Bano versus Iftikhar Muhammad, when a wife she was being ignored by the husband, though that only way to win him back was to waive Mahr, her permission of Mahr was considered without her consent as was not binding on her. Let me see what are the kinds of dower. In this screen we can say the kinds of dower is divided into two. Specified dower and proper dower, that is Mahr-e-Misal, also known as customary dower. Again, specified dower will be divided into prompt dower, that is payable immediately on demand, and deferred dower, that is payable on the dissolution of marriage either by divorce or the death of the husband. Let me go further. The kinds of Mahr, that is which I said is specified and customary or proper Mahr. And the specified Mahr also be said as a Mahr-e-Musamma, and a customary or a proper Mahr will be said as a Mahr-e-Misl in Arabic terminology. And specified dower can further be divided into two categories. That is prompt, which is said Muajjal, MU space AJJAL, that is Muajjal, and deferred, that is said as a Muwajjal, MUWAJJL, Muwajjal, that is deferred dower. And specified dower, we can say, means the dower has been agreed upon by the parties at the time of marriage. Such a dower can be settled before the marriage, at the time of marriage, or even after the marriage. In case of a minor or a lunatic, the guardian can fix the amount of dower. Dower fixed by the guardian is binding upon the boy, and after attaining the puberty or majority, he cannot take the plea that he was not a party to it. And as I told you, that sometimes I use Dower, Dower, sometimes I am using Mahr, but both are the same. Mahr is in a Arabic terminology, and that is Islamic terminology, and equivalent is Dower, that is a English terminology. Please note that point. Now let me continue. A husband can settle any amount as a dower to his wife, even if that leaves nothing to the heirs, but he cannot settle for less than 10 dirhams in Sunni law. In Shia law has no minimum for those Muslims who are so poor that they cannot even pay 10 dirhams. They can teach the wife Quran in lieu of paying meher. Yes, those who could not have any money, even teach the wife Quran in lieu of paying meher also is a sufficient meher. Now we will see the specified dower can further be divided into two categories. I said one is prompt, that is a muajjal, and the second is deferred, that is a muajjal. And we will go one after another what it means. Muajjal. As the name suggests, muajjal dower means that the dower is payable immediately upon the marriage. Here, dower is payable immediately upon the marriage, that is called muajjal. In Rabia Khatun versus Mukhtar Ahmed, it was observed that the wife may refuse to live with her husband and to admit him to sexual intercourse so long as a prompt dower is not paid. If the husband sues her for restitution of conjugal rights before sexual intercourse takes place, non-payment of dowry is a complete defense to the suit, and the suit will be dismissed. If the suit is brought after sexual intercourse had taken place with her free consent, the proper decree to pass is not a decree of dismissal, but a decree of restitution. That is a conditional on payment of dower, and this we have seen in earlier case law also. And this principle was first laid down in Abul Khadir versus Salima, and we discussed earlier. Now we will see the following rights of wife is having when the meher is not paid. Again we will repeat here in point wise. When the meher is not paid, when the meher is a prompt meher, that is a muajjal. Number one, the wife has a right to refuse cohabitation with the husband until she is paid the dower. Yes. Number two, if the wife is a minor, the guardian can refuse to allow the wife to be sent to the husband until dower is paid. Number three, only after the payment of dower, the husband is able to enforce the conjugal rights. However, if the marriage is a consummated, the wife cannot refuse cohabitation after that. Number four, prompt dower does not become deferred after consummation, and the wife has the right to demand and sue for it at any time. The fifth, the period of limitation starts after demand and refusal, and it is of the 3 years. Now we will see what is deferred mahar. That is called muwajjal. M-U space W-A-J-J-A-L. Muwajjal. It means that the dower is payable upon dissolution of marriage, either by divorce or by death of the husband. And we will see again what are the rights of the wife is given below. I repeat, the repetition makes us for the remembrance also. That way repeated again, or repeated here. Yes. Number one, even though it is a deferred, an agreement to pay may be before is valid and binding. Number two, a wife does not have a right to claim dower, but a husband can treat it as a prompt and transfer the property as payment. Number three, a widow can relinquish her claim to dower at the time of the funeral of the husband by reciting a formula, but her relinquishment must be a voluntary act. And the fourth one is the interest of the wife in deferred dower is a vested one, and her heirs can claim it after her death. Let me see the another customary or proper meher, that is called meher-e misl. Mahr space I space MISL. Mahr-a-Misl. That is Arabic terminology, and its equivalent is customary or proper mahar. If nothing is said about the dower at the time of marriage, the wife may claim to have a reasonable amount of dower settled for her, even if the marriage was contracted on the express condition that she should not claim any dower. In fixing the proper dower, the court is guided by the amount of dower settled upon other female members of the family of the wife's father, as for instance the father's sister. In such cases, the social position of the husband and his means are not of much importance, as the Hidayah lays down. The wife's age, beauty, fortune, understanding, and virtue must be kept in mind when fixing the proper dower. Thus, the Prophet once allowed the marriage of a poor Muslim for a silver ring, and on another occasion merely on condition that the husband would teach the Quran to his wife. If it is enough for the poor to pay the dower. When a husband is a poor, even if he teaches how to read Quran to the wife, it is enough. That is amount to be a dower. Under Shia law, the proper dower should not exceed 500 dirhams. In one case, a Muslim married a Christian woman in England. The court observed that the marriage was governed by Muslim law, and therefore the husband could divorce his wife by talaq. The court also held that wife in turn could also claim dower, although no dower was initially fixed at the time of the marriage. In such cases, proper dower could be claimed, that is a dower which would be payable to a woman of similar status and circumstances. That is observed in the Marina Jatai versus Nuruddin Jatai. When the amount of dowry is not fixed in the marriage contract, or even if the marriage has been contracted on the condition that she will not claim any meher, the wife is entitled to proper dower. The amount is to be arrived upon after taking into consideration the amount of dower settled for other female members of the father's family. It is also regulated with reference to the following factor, which I discussed or explained earlier. But again, we'll see those points where meher is not fixed over there. In proper meher, these are the points should be considered to fix the meher. Number 1, age, beauty, fortune, understanding and virtue of wife. Number 2, social position of the father. Number 3, dower given to her female paternal relations. Number 4, economic conditions of the husband. And the fifth one is, which is set to the last, circumstances of the time. There is no limit on the maximum limit in Sunni law, but Shia law prescribes a maximum limit of 500 dirhams, which was the amount paid by the Prophet Muhammad for his daughter Fatima. At the time 500 dirhams, now you can change it what is the present value is concerned. Let us see now the differences between Shia and Sunni law on meher, that is on dower. Sunni law says minimum of 10 dirhams for a specified dower. Shia law says no minimum limit. Sunni law says no maximum limit for the proper or specified dower. And Shia law says dower above 500 dirham is considered abominable legal. And Sunni law says if dower was not decided or marriage was done on condition that no dower will be paid, dower shall be payable if marriage is dissolved by the death, irrespective of whether the marriage was consummated or not. In Shia law, dower shall be payable only if the marriage was consummated in the case. In Sunni law, an agreement that no dower shall be payable is void. In Shia law, such an agreement by sane and adult wife is valid. In Sunni law, in absence of a contract, only a reasonable part of the dower is considered to be the prompt, rest is deferred. But in Shia law, whole dower is to be paid. I repeat the last point. In Shia law, the whole dower is presumed to be prompt. That is the in Shia law. And this is the end of my today online class. Thank you very much patiently listening my online class. Goodbye.